Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with high conflict disputes, we are here to provide clear and practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. And while this isn't legal advice, it is designed to empower you with the knowledge you need to move forward and to do so with confidence. Today, I want to talk about a recent Ontario Court of Appeal decision that brings important clarity to one of the most disputed and most misunderstood issues in family law: the date of separation. The case is Kasabian v. Markarian, decided in 2025, and it answers a question I hear all the time. We were basically done years ago. Doesn't that mean we were separated? Well, as this case confirms, the legal answer is often no. Before getting into the case, let's ground this in why the date of separation is so critical. In Ontario family law, the separation date affects equalization of net family property, limitation periods, spousal support analysis, disclosure obligations, and sometimes whether a claim survives at all. Being off by just a few years can mean hundreds of thousands of dollars, if not more. That's why courts take this issue very seriously and why Kasabian v. Markarian is such an important decision. In this case, the parties married in 1998 and had 2 children who were adults by the time of trial. The husband claimed the marriage ended in December 2014 when they stopped sharing a bedroom. The relationship became emotionally distant. The marriage was, in his words, in his view, effectively over. Well, the wife, however, said the separation didn't occur until May 16, 2021, the day that she clearly told her husband she wanted to separate. She confirmed that intention by email, identified that date as a separation date for financial disclosure. Importantly, when she sent that email, the husband did not dispute the date. At trial, the judge accepted the 2021 separation date, and the husband appealed. The Court of Appeal was asked one key question: did the trial judge make a palpable and overriding error in determining the date of separation? The answer was no, and in explaining why, the Court of Appeal provided extremely helpful guidance here. The court reaffirmed something very important. There is no single factor that determines the date of separation. Instead, separation is assessed through an objective, fact-driven analysis. What really matters, according to the Court of Appeal, is this: was there a clear change in the objective characteristics of the relationship at the alleged separation date? That means not unhappiness, not emotional distance, not sleeping in separate bedrooms, but a demonstrable shift in how the relationship functioned. One of the most important parts of this decision deals, in fact, with intent. The court made several clarifications that practitioners and clients need to understand now, so pay attention here. First, it's not the stated intent that matters most, it's the true intent, as shown by conduct. Second, separation does not require agreement or a meeting of the minds. One party can unilaterally decide to separate. But third, and this is where people often go wrong, that intent must be objectively communicated through words or actions. In other words, separation isn't something that lives quietly in your head. The court also emphasized something very realistic. Separation is often a process, not a single event. Relationships don't always end cleanly on one date. They tend to unwind over time. The Court of Appeal upheld the trial judge's findings based on the evidence. After 2014, the parties continued to live as a married couple, filing taxes as married, taking no steps to divide assets, seeking no legal advice, traveling together as a family, sharing meals, and maintaining normal household routines. Most importantly, when the wife clearly stated in May 2021 that she was separating, the husband did not object, and that silence mattered. The court also rejected the idea that a difficult marriage equals separation, or that consulting a divorce coach automatically means the parties were separated. Thus, the Court of Appeal dismissed the appeal in this case. Now, what are the takeaways from Kasabian v. Markarian? It's simple but critical. Separation is determined by what objectively happened, not by what one party later claims they felt. Courts look at conduct, consistency, and evidence. If separation is claimed, it needs to be clearly communicated and supported by how the parties actually lived, financially, socially, and publicly. Unhappy marriages don't automatically equal separation, and silence or inaction can matter just as much as words. This decision brings clarity to a highly emotional issue and is now essential guidance for anyone navigating or advising on separation in Ontario. Well, that's it for this episode and Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need any guidance at all, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next week.